Okay, good afternoon, everyone. I'll try to move this along as we come close to the end of the day and hit the ethics portion, which I'm sure everyone's here to listen to. We'll get over this hump, though, and talk about custody. I chose this rather provocative title to hopefully pique people's interest and let people think that maybe I'm going to be talking about the selfish parent and oftentimes in our case the selfish mother who's trying to protect her custodial rights. Is that better? Okay. I'll have to lean down. Now I know I was told I should have the lavalier. Okay, here we go. But what I'd like to do is, the topic is really going to be focusing on custody today and what the recent case law has shown in relation to joint legal custody, sole legal custody, joint physical, and sole physical custody, and what the appellate court cases have done in the treatment of these particular custodial scenarios. So I'm going to be going through a number of different areas in our case law addressing those topics as we move forward in the presentation. And I think the first thing we want to take a look at is, there we go, the statute that addresses custody, which is Missouri Revised Statute 452-375. That specific statute defines custody as joint legal, joint physical, sole legal, and sole physical. That is what custody is pursuant to Missouri statute. That's the authority that we look to and the courts look to when evaluating a familial situation at trial and making determinations regarding both physical and legal custody. Now, joint legal custody, we'll see the definition here. It's joint decision-making authority regarding the health, education, and welfare of a child, unless otherwise allocated, apportioned, or decreed, parents confer with one another. That's the structure, the very basic foundation of joint legal custody. Typically, practitioners and certainly clients get confused as to what joint legal custody or what legal custody really is. Legal custody doesn't address the day-to-day decisions of a child, whether a child's bedtime should be 9 o'clock or 9:30, or whether a child should have a certain food in the morning for breakfast, or these minor day-to-day decisions are not what joint legal custody speaks to. It's speaking to the larger decisions regarding health care, where this child might go to school, what medical treatment this child should be receiving. And then the catch-all of the welfare of the child is a more subjective determination, but still speaks to the magnitude of larger decisions that impact a child's everyday well-being. Joint physical custody pursuant to the statute doesn't mean equal time with two parents. What the statute defines as joint physical custody is that each parent have significant time, but not necessarily equal time with the children, shared in such a way as to ensure frequent and meaningful contact with both parents. And further on in the presentation, we're going to see more definition to what significant means when evaluating whether a custodial schedule meets the criteria of joint physical versus sole physical custody. The statute actually gives an order of priority that the court should consider before making a determination as to what custody should be ordered in a particular case. And it goes in order as set forth in 452-375.51. The court first considers joint legal and joint physical custody. Then, if that is not appropriate for the particular family, the court should next consider joint physical and sole legal with one parent. The third order of consideration is joint legal with sole physical, and the fourth being sole legal and sole physical, and then the fifth being third-party custody. And this would be in circumstances where parents are unable or unfit to fulfill their role as a parent. As it relates to legal custody, we're going to talk about a number of cases that are dealing with interpretations of legal custody and how the appellate court has treated that upon review of the trial court's decisions regarding legal custody. The thing to remember, and it's very important to realize and understand, and we as domestic practitioners, I think, are fairly aware of this, that the burden at the appellate level in challenging a trial court's decision regarding legal custody is extremely high. In order to be successful, at the appellate court level, we have to prove that the trial court's decision regarding legal custody was against the logic of the circumstances, was arbitrary and unreasonable. The trial court's determination of a custody matter is given more deference at the appellate court level than any other matter that is appealed. And the case of Hankins versus Hankins, it's a 1996 Western District case. In this particular case, father was appealing a sole legal custody award to mother. And substantial evidence was presented and found by the appellate court that disagreements regarding naps, diet, medical treatment, preschool support, supported the trial court's opinion that joint legal custody was not appropriate for this particular family. Father was appealed, and the appellate court affirmed the lower court's order, stating that there was substantial evidence presented to support why joint legal custody would not be appropriate for this particular family. And then the court then affirmed the lower court's finding. You're going to find a lot of cases on appeal that are appealing the issue of legal custody are often affirming the trial court's determination because of this extraordinarily high burden of proof at the appellate level. In re, the Marriage of Barnes is a 1993 case that speaks to what the statute provides in the earlier slide that we saw, which was section 452.375.1, the order of determination as to what custody considerations the court must take or must undertake in making decisions. And again, that order of preference starting with joint legal and joint physical custody. If joint legal and joint physical custody is found to be appropriate for a particular family, the inquiry really at that point ends. If not, it moves on then through the statute, through the remaining custodial options. In this case, merely affirms what the statute requires. .2, 1 through 8 are the 8 factors the court must undertake the evaluation of in determining or assessing custody in both legal and physical custody. These are 8 factors that the court has to communicate through a narrative in its findings before making a decision. And in this particular, the particular elements include the court must consider the wishes of the parents as to what custodial arrangement is best for the children, the need for the children to have frequent and meaningful contact with both parents, the interaction and interrelationship between the parents and the child, as well as the child and siblings and other individuals that are within their daily life in one or the other household. Which parent is more likely to promote frequent and meaningful contact with the child with the other parent, being the 4th consideration. The 5th is the child's adjustment to their school, community, and home life. The 6th being the mental and physical health of the individuals, including a history of abuse. The 7th being the intention of either party to relocate, so whether one parent's going to be leaving the marital residence or leaving the metropolitan area. This is a consideration the court must evaluate. And then finally, the wishes of the child. This becomes, and we'll see that this becomes a little more of a variable that depends on the age of the child, the maturity level, as domestic practitioners, we found that children tend to have to be around the age of 12 or 13, where there's more substance and authority considered by the court of the child when they reach that level to express a preference. But the preference in and of itself is not determinative of custody. Hall versus Hall is a 2011 Western District case which re-emphasized the necessity of a trial court to engage in a discussion of each and every one of those points within the statute when making a custody determination. In this particular case, the court merely listed the 8 factors and then concluded summarily that based on the court's assessment and evaluation of the 8 factors, that the best interests of the child were given based on a certain legal and physical custodial arrangement with no further explanation about the actual elements of the statute. And the appellate court on appeal reversed and remanded the case because the appellate court said the trial court should not be just listing the 8 factors that are set forth within the statute. There should be a discussion of each factor and how each factor applies to the particular family situation before a determination is made by the trial court of both legal and physical custody. When evaluating legal custody, what the court does in assessing the appropriate legal custody for a family situation is they go through an analysis of determining, one, whether or not there's a commonality of beliefs concerning parental decisions, and number 2, the ability of the parents to function as a parental unit. These are the 2 factors that the courts examine to determine whether or not the first legal custody scenario dictated by the statute would be appropriate for this particular family. In the Dunkel case, this Eastern District 2005 case, it spelled out more specifically the fact that, and confirming that the legislative intent in Missouri has expressed a public policy favoring frequent and meaningful contact of parents. And in this particular case, mother was appealing an award of sole legal custody to the father. And in the facts of the case were such that mother suffered from a bipolar disorder for which she was on certain medication. Mother lived in St. Louis and father had relocated to Columbia, Missouri. And the court was concerned, although it called it a close case, was concerned about the distance between the parents' residences and concluded that joint legal custody would not work. Therefore, father was granted sole legal custody. This case was then appealed by mother, and the appellate court reversed that decision because they felt that the joint legal custody could not hinge on merely a factor of distance between parents, that more of a factual factor analysis under 452.375.2 was required for the court to undertake before making that final decision. Now, although legal custody, joint legal custody is a preference, it's very specifically stated not a presumption by the court. And the Malloway case specifically stated that particular point. In this case, mother was appealing an award of what was referred to as primary legal custody, which we know statutorily it's actually sole legal custody. And it was apparently awarded to father. Evidence of physical and verbal altercations between the parents, including custody exchanges, and was presented. Find this here. And the court found that in this particular case that the joint legal custody was not a presumption, that the trial court had to look to it, but they did not have to order it in a particular case. Now, There are cases out there, and as a domestic practitioner, I think we've dealt with them where we're negotiating a settlement and the opposing party and counsel are suggesting that we enter into a legal custodial arrangement that provides for joint legal custody, but it provides that we essentially the final decision a final decision regarding the child would ultimately be made by one parent after conferring and consulting with the other parent. This is something that people have done by agreement, but this case, the Brown case, it's a 2010 Eastern District case, specifically states that the court does not have the ability on its own to enter such an agreement or enter such an order. The order itself, the language of the judgment, and this is an appeal by father of this legal custody, stated that mother shall confer with father before making final decisions on issues affecting the growth and development of the children. However, in the judgment, it references joint legal custody. The appellate court found that the language was inconsistent with the label, and therefore the appellate court was not sure what to conclude as it relates to the actual legal custody in this particular case. So ultimately, the court reversed the order, remanded it back to the trial court for a specific determination as to the custody that was actually ordered. Aubuchon v. Hale is a recent 2012 case, again dealing with legal custody. In this particular case, mother was appealing the judgment denying a request to modify the decree to grant her sole legal and sole physical custody. What happened in this particular case was the court entered an order that stated that the parties were to continue with the therapeutic supervised visitation program until they were released by the counselor, and then when a counselor believes the relationship has been normalized, the prior parenting plan as contained in the prior judgment, because this was a motion to modify, that the judgment would be in full force and effect, and that the determination of a normalization shall be memorialized by a letter from the counselor to each parent and then a copy to the court. So in essence, what the court has done, it has abdicated its authority to the determination of an outside non-judicial therapist. The court, this was appealed, and the court concluded that this was an inappropriate abdication of that power, that a therapist or third party other than the judge should not be making these decisions, and the trial court cannot structure an order that vests that authority in someone other than the court or the judge itself. So that was reversed and then remanded. This particular case makes it very clear. It's just, like I said, in the 2012 ruling. Typically, when dealing with legal custody, arguments are often raised that these parties can't get along, they're not able to work together, legal custody is not possible because the two cannot work as a parental unit, which those are the buzzwords, of course, the court has to listen to and follow, but it's a very subjective determination, which is why the appellate court grants so much discretionary authority to the trial court when it comes to custody issues. But the Vogel case is probably a good example of why you should not give up too quickly when you're dealing with parents in conflict in asking for a joint legal custody award. Mother was appealing the denial of cross motions by both father and mother. They were requesting a modification of a joint legal custody plan that was put in place by their original judgment, and father felt sole legal was appropriate and the joint legal was not workable, and mother felt the same thing, that sole legal was not appropriate, or joint legal was not appropriate, and sole legal with her was the appropriate custodial arrangement for these children. This particular case, although appealed, because what ultimately happened, the trial court denied both cross motions and maintained the existing joint legal custody plan, despite the fact that two parties were seeking a change from joint legal to sole legal. So the presumption that because both parties are seeking sole legal doesn't necessarily mean that this joint legal will be disposed of. And this case shows that very fact. the courts felt that there was some alleged acrimony, and they even went so far as to say there may be future acrimony. But there was enough substantial evidence to show the parties' efforts to work together in making decisions together that the trial court's ruling or determination that the joint legal custody plan should remain in place should be affirmed. So in this particular circumstance, this is an example where you might have two parents that claim they don't want sole legal, but joint legal remains in place. In evaluating a legal custody plan, one of the 8 factors to be considered that we stated earlier in one of the slides regarding 452, 375.2, and more specifically point 6, states that a history of abuse is relevant in the determination of custody, and again, legal and physical custody. This 2007 case from the Western District was a matter where father was appealing an order of sole legal custody of the party's children that was granted to mother on the grounds that father was not allowed to testify to alleged physical altercations or physical attacks by mother to father. And at trial, when father was attempting to testify to that, mother's counsel objected on the grounds of relevancy. The court, upon further inquiry, heard from counsel that counsel for mother claimed that it wasn't relevant because children weren't present during the alleged abuse event, and the court agreed and excluded the testimony. The appellate court disagreed and said that it's not, irregardless of whether the child was present or not, physical abuse or a history of abuse between parents not involving the children is still a relevant consideration in determining whether the legal custody result in a case. So it was reversed and remanded for further testimony on that particular fact. Oftentimes, as domestic practitioners, I think we've run into situations where clients come to us and are claiming that the legal custody arrangements are not working and cite a particular event or an occurrence to illustrate their point as to why it's failing. This particular case, decided in 1998 by the Southern District, was an issue where there were cross motions to modify the joint legal plan to a sole legal plan. Mother apparently claimed that father was failing to keep her advised of medical decisions, that father had made choices regarding the surgeon for their child for a tonsillectomy and had excluded mother from that decision, and also taken the child to the ER without telling the mother until a week later. And another allegation regarding a tetanus shot that was, an inoculation for tuberculosis that apparently was given to the child without mother's knowledge, although the evidence showed that mother had also attempted to do the same thing. The court found that these allegations in and of themselves were a non-recurring event, and because of that, they felt it did not rise to the level of changing the actual legal custody that's in place. So the judgment ultimately was reversed and remanded back because the appellate court felt the trial court had taken a sledgehammer by changing legal custody based on certain individual events that were not recurring. Again, citing back to the public policy of trying to preserve the joint legal custodial arrangement that existed. Another more recent case, this is a 2003. This, again, speaks to, and I've tried to pull a lot of the cases out where legal custody on appeal was actually changed, which is more rare, obviously, based on the burden of proof than those that are affirmed. But it helps us see where the appellate court is willing to make a change and invade and make decisions contrary to what the trial court may have made. And this is one of those cases where mother was appealing a judgment changing joint legal to sole legal custody to father. Apparently, there had been evidence presented by father that mother was not forthcoming regarding certain insurance information for the child, and even went so far as to say there were some disagreements regarding daycare placement and the choice of a particular parochial school, which logically you look to that and think, well, these are legal custody decisions that directly reflects or deals with the welfare of the child, deals with their education, so perhaps the joint legal custody would not work. The appellate court found that these disagreements did not appear to rise to the level that the parties could not make decisions regarding the well-being of the child. In essence, agreeing that the changing of joint legal to sole legal was inappropriate because these particular events were not of such importance as to require a disruption of the original legal custody plan. So again, a situation where the appellate court felt this would not be in the best interests of the child. The next case, this is a 1997 case, a little bit older, but also speaks to the joint legal custody situation where mother was appealing a joint legal custody award. That father argued that the trial court agreed that an award of joint legal is necessary to prevent mother's interference with father's rights to custody. And this is apparently the trial court felt that the implementation of a joint legal custody award would somehow assist in preventing mother's interference with father's legal custodial rights. So the trial court entered the joint legal custody to force the parents then to work together. The appellate court disagreed. They felt that legal custody was not meant to ensure that a parent maintains a relationship with a child. Again, we're going back to what's in the best interest and the 8 factors. It shouldn't be used to encourage a relationship between the parents because, again, going back to that 2-factor test, there was no evidence to show that the parents could work together as a parental unit and had a commonality of beliefs. So going back to the basic elements of a legal custody determination, the court felt that this was not the proper reason to award joint legal custody. Now, moving into the physical custody topic, the statute, again, does not give specifics as to what joint physical custody is. The case I have cited here is one of the first cases here in the Eastern District that dealt with this issue. It's actually a case that we were involved in. Tried the case, we represented father, big surprise. Another firm represented mother. We tried the case. It was a situation where mother was a stay-at-home parent. Father worked outside the home. There were 2 children, actually twins. There were allegations of sexual abuse made by mother against father that were unsubstantiated. Mother was asking for sole legal and sole physical custody. Father was asking for joint physical and sole legal, although ultimately, at the beginning it was joint legal, but it was later amended. The trial court came down with a ruling awarding to father sole legal and sole physical custody with a schedule that provided mother 43% of the custodial time during the school year, and it was a sharing of the summer schedule during the summer break. On appeal, mother appealed a number of issues, but the one that was successful was the appeal of the designation of custody that mother actually received. Although the trial court delineated the custody as sole physical custody, the appellate court disagreed, finding that that percentage of time that mother received with the children was significant, and that in fact that the court had awarded her joint physical custody. So instead of remanding it, the appellate court was able to reverse and correct the judgment at the appellate level to relabel the custody joint physical custody. Now, having done that, the question now becomes, well, what constitutes joint physical custody? So I did a bit of research to find recent cases that have defined physical custody as what is joint physical. Found a recent case in the Western District in 2012, the Clark case. In this particular scenario, the parent's father was granted custody at a schedule from 7:15 a.m. in the morning on Wednesday to 4:45 p.m. on Thursday on week 1. And week 2, it was 7:15 a.m. on Wednesday to 4:45 p.m. on Friday, alternating holidays with the other parent and 5 consecutive days with the child during the summer break. Not even close to a 43% of the time. In this case, the appellate court confirmed that that is a joint physical custody schedule. They found, the appellate court for the Western District found that is significant time with a child, and as a result, is not sole physical with mother. It's actually joint physical with mother, although substantially different than the custodial time that mother has with the child. In a similar case, in re Marriage of House, which is actually cited by the Clark case, the parent has a schedule very similar to Siegenthaler, which is an every other weekend schedule, no midweek visitation though, alternating holidays, and 1 week in the summer. And in coming to its conclusion in Clark, they rely on House because House also concluded that schedule was in fact joint physical custody. So in this situation, physical custody, in order to have sole physical, it would have to be substantially limited, which is really rather surprising based on the 2012 Clark decision. But apparently, short of a long-distance custodial arrangement where contact would be fairly infrequent, as long as there is periodic, frequent contact, regardless of the extent of the length of time, it seems to fall within the category of joint physical custody. Now, relocation is a factor that comes into play where truly, and as a domestic practitioner, there is a winner and a loser in these cases. As in most of our other cases, they're truly, it's a gray area. But in this case, when a parent wants to relocate with a child, it's going to be a thumbs up or a thumbs down, and they're often very difficult to settle. The statutory authority is, of course, 452-377. The statute is sets forth a framework within which a parent who is relocating must notify the other parent within a certain period of time, 60 days prior to the proposed relocation, of the relocation with the child. There is a list of information that must be provided in the notice, including address, contact information, where the child might go to school. It's very detailed, and it's based on what the relocating parent knows at the time the notice is given. And then there is also a structured response that the non-relocating parent must follow in order to object. In the Smith case we have, the Smith case spells out very clearly after the most recent, or the latest, I should say, amendment to 452-377. It shows what the burden of proof is for a relocating parent to prove or successfully prove that the relocation of the child is truly within the best interests of that child. First, they must show that the relocation was done or made, or the proposed relocation is done or made in good faith, meaning that that parent, the relocating parent, is not relocating the residence of the child to deprive the non-relocating parent of time with the child. And then secondly, whether or not the relocation is within the best interests of the child, which requires a 452-375 analysis of the 8 factors in order to assess whether a relocation is appropriate for that particular child. The Schlattman case, which is a 2006 Western District case, speaks to that more specifically in the sense that the court specifically found in that case that the relocation of a residence of a child still requires the analysis of the 8 factors in 452-375. And again, relocation is relocating the principal residence of the child. So even though you might have a joint physical custody arrangement, there is a parent who has the principal residence of that child, which is typically based on the amount of time they're spending, although not always, and that principal residence is what dictates who the obligated parent is if they choose to relocate the residence and when 452-377 notice is required. This is a rather interesting case that was decided back in 2011. In this particular situation, it was a paternity action. And in this case, father had filed a paternity action when mother was indicating an intent to relocate to the state of Ohio with the child. Ultimately, the court granted sole physical custody to mother, but ordered mother to relocate back to Missouri. The matter was appealed by mother, and of course the appellate court concluded that unless mother agreed to relocate, and absent any statutory authority, because 452-377 is not authority that can require the court to order a parent back, that the court did not have jurisdiction to order mother to relocate back. The 452-377 authority is vested within the court to order the relocation of a child back to a jurisdiction, which creates the need for particularly an objecting party to file, along with their objection to relocate, depending on their custodial circumstances, a motion to modify, so that the court then has the option, if the custodial parent or the relocating parent refuses to return, it gives the court the authority then to transfer physical custody of the child should the relocating parent not choose to return back to the state. As I stated earlier, the statute has very specific requirements regarding the notice of relocation. This is a case, it's a 2013 case, very recent in the Western District, where mother had appealed the denial of her relocation and in part relied on the fact that father failed to comply with the time restrictions set forth in 452-377 to object to the relocation. As the statute reads, if there's a failure to object within the time constraints set forth in the statute, the presumption is the child may then relocate. In this particular case, father did, and it was an undisputed relocate, or did not provide the notice within the statutorily required period of time. The court, though, still denied her relocation. Mother appeals. The appellate court reviews the record and found that mother's notice provided a city and state of relocation and also a brief description of a residence that she claimed was 4,000 square feet. But on further investigation of the evidence, it was the trial court evidence showed that she did know of an address, but did not provide the specific address in the notice, and that the address was actually a modular home on a small piece of land and not the 4,000 square foot home she had set forth in the notice. Because of that misleading information, the courts felt that father was not given adequate notice and therefore could not comply with the restrictions of the time restrictions set forth in the statute, finding his objection timely. So, although as a relocating parent there is a fairly bright line rule as to when a relocation notice must be objected to in order to prevent the relocation. Make sure that that relocation notice has as much of the information you know that's required to be produced pursuant to the statute. This is an interesting case. It's a 2002 Western District case. In the judgment, and father appeals the judgment provided for a one-time right to relocate within a specific geographical area without either party having to comply with 452-377, and this was a ruling by the trial court. Father appealed, and the appellate court concluded that the trial court was not able to prevent or actually to prevent or not require a party to provide the requisite notice under 452-377 by granting this one-time right to relocate, that the trial court had stepped outside of its jurisdiction to make this order and was reversed and remanded for correction of that particular order. So the question becomes, if a court can't do that, then can the parties agree to that? There isn't case law that specifically addresses that, but as in other scenarios where you might have something that if both parties agree, even though the court might not have jurisdiction, an agreement may be able to be accomplished with that provision. I would never advise you to do that simply because the statute is the controlling factor, and in fact the statute requires the components regarding notice to be in every decree, so it's a dangerous experiment that you're undertaking by doing that. But certainly the trial court steps beyond its ability, beyond its jurisdiction by ordering such a ruling. Lowry is a case, it's a 2009 Eastern District case. It speaks to the need for a relocating party in responding to an objection filed by a non-relocating parent to provide substantial evidence of the proposed relocation in order to succeed. In this particular case, mother was wanting to relocate with the child to the state of Florida, and initially the trial court had granted the relocation. Father appealed, and the appellate court reversed the relocation, stating that there was not sufficient evidence to prove or to allow the court to undertake the analysis of whether the relocation was in fact in the best interest of the child. Mother had presented no evidence regarding the living environment, where the child would attend school, where a daycare provider for the child, where mother would work. There were these essential components that the court really required in order to do the 452-375 analysis of the 8 factors, and the appellate court felt that the trial court could not do that without this information. So it was reversed and remanded for further consideration. This is a 2011 case, which I think helps us understand that relocations are rarely ever reversed. They're rarely ever challenged, or they are challenged at the appellate level, but the appellate level rarely finds grounds or substance to reverse a denial of a relocation. And in reviewing cases involving relocation, this becomes apparent that the majority of those where the relocation has been denied, there is not a reversal. I bring this up as one of the last topics to discuss today, because this is a topic that many people bring up as reasons or for support of why physical or legal custody should be sole or joint, challenging a parent's interference with another parent's rights and contact with a child. Parent alienation syndrome, and we find in domestic relation practice that many clients have heard this term and use it frequently and freely. And I don't think a lot of us truly understand what we're dealing with when we're talking about parent alienation syndrome, or PAS. It's actually a syndrome that was identified by Dr. Richard Gardner. He's an American psychiatrist who, frankly, identified this back in the mid-'80s at a time when there was a tremendous spike in sexual abuse allegations and divorce cases. And he identified what he describes as a syndrome that of brainwashing and programming that tends to occur in child custody cases. He believes that specifically there are 8 factors in evaluating whether a child is the victim of a parent alienation syndrome. In such a syndrome, there is what's considered a favored parent and a target parent. The favored parent, of course, being the actor of the alienation, the target parent being the alleged victim of the alienation. The 8 symptoms I've outlined the four in this slide and then the four in the next. First being denigration or hatred toward the target parent. The second being weak, absurd, or frivolous rationalizations for this deprecation and hatred by the child of the targeted parent. The third being a lack of usual ambivalence about the targeted parent. And then the fourth being the lack of guilt over the treatment of the alienated parent. And again, these are symptoms. The fifth is a reflexive support by the child of the favored parent. Then we have the sixth being the use of borrowed scenarios or phrases from the alienated parent when talking to the child about the target parent. Strong assertions that the decision to reject the parent is theirs, that the child is an independent thinker and that they are not under any undue influence from any third party. And then the denigration, not just of the targeted parent, but also family members, extended family, friends of the targeted parent. The important thing to keep in mind with parental alienation syndrome, it's really not specifically recognized by the medical community, and it's not typically recognized by the legal community in the sense that it tends to outline a series of symptoms which are relevant to a custody determination, but when you're encroaching upon a diagnosis of a syndrome that is not recognized, you're going to run into evidentiary problems at trial. When I looked through some cases to update myself most recently addressing parent alienation, I came across a couple. This is a Southern District case in 2008, and in this particular case, one of the most significant factors in granting joint legal custody of the child to both parents was the possibility of parental alienation syndrome. What happened in this case is that the court felt that the behavior of one of the parents, using Dr. Gardner's label, a favored parent, apparently created concern about father's ability to participate in the upbringing of the child and the decisions of the child, and that the court was entering some sort of joint legal custody arrangement to help solve that problem. This is a little contradictory because the case I had mentioned earlier in this presentation indicated that joint legal custody was not meant to improve a relationship between a parent and a child, yet this seems to indicate that it's appropriate to facilitate such a relationship. I think there is a bit of a conflict. We're dealing with an Eastern District case on the one, and this is a Southern District. However, both are good law. But this is a situation where the courts, they're not affirming the existence of parental alienation, but they're identifying it as a descriptive term of the behavior that the favored parent is exhibiting and causing issues or problems for the target parent. A curious thing, though, in looking through these cases, again, because it is not a recognized medical condition or a psychiatric condition within the medical community, this particular case and then the next one that I'm going to be citing, no one, at least the record, did not seem to reflect a challenge of whether such evidence should be admitted into evidence. And frankly, this next case, it's a 2010 Southern District case. There was substantial evidence of a therapist opining that the children in this particular case, it's a mother and father were divorcing 6 children. So all 6 children were believed to be the victims of mother's alienating behavior of father, but the 3 were so old, were teenagers, they were seen as participants in the alienation to alienate the 3 younger children. And what happened in this particular case is that the 3 younger children, that father was granted sole legal custody of the 3 younger children because there was a belief that mother was behaving in such a way that it was against the best interests of the child and excluding father, etc. But when you look at the judgment itself, you've got an expert testifying to parent alienation syndrome, you've got a GAL testifying to parent alienation syndrome, and yet I couldn't find anywhere in the record where mother's attorney objected to the admissibility of that evidence using the Frye test. I mean, is this, and again, Fry versus United States, the very basis of evaluating expert testimony and and evidence regarding health conditions, medical conditions, to name just a couple, I think you would be successful challenging that under the Fry test to prevent or exclude references and diagnoses of therapists and testimony from GALs regarding a parental alienation syndrome or the existence of such a thing. That doesn't mean that the behavior or the characteristics which were evidenced in the 2 previous slides regarding the 8 symptoms, certainly that evidence would be admissible in assessing or evaluating the legal and physical custody of the parents, but in and of themselves. But to group them together, label it a psychological condition or psychiatric condition, you're really on shaky ground, I think, if you're attempting to try and base your case on on a parent alienation syndrome label. So I think when dealing in this particular case, again, the transcript is peppered with the diagnosis and the testimony, but in looking at it, the actual ruling, the court doesn't make findings of parent alienation. The court did appropriately identify particular behaviors in their 8-factor analysis in supporting its conclusion, giving father sole legal and sole physical custody of the 3 youngest children. So I think from the appellate level, or from the appellate perspective, they could uphold that trial court decision because there is not a specific finding. In fact, it's really not addressed other than the recitation of the actual testimony about parental alienation syndrome. So I think that's an example where evidence may be presented. You can take that chance that there won't be an objection or an inquiry as to whether that's an actual syndrome that can be testified to. And in this case, no one did. Father was still successful, and the trial court was savvy enough not to make findings on that particular syndrome, which could cause problems at the appellate level. But it's a buzzword or a buzz phrase that unfortunately a lot of clients tend to use for single incidents of behavior that might fit within categories of the 8 symptoms, but in and of itself might not demonstrate a practice or a history of this type of behavior. So in moving forward, again, I'd focus on the symptoms and less on the label. So in conclusion, I have to say that again, public policy favors joint legal and joint physical custody. It is a first consideration by the court in evaluating the appropriate custodial arrangement, and then move to the next group, whether it's sole legal or sole physical. But it appears as though that the appellate courts are willing to reverse such orders if the proper analysis has not been done to save or preserve a joint legal and joint physical custody arrangement. And if you have a case where you've got a parent who is indoctrinating behavior within the child that you believe falls within the general and unofficial label of parental alienation, certainly the employment of an expert is important, but beware of the potential admissibility of that syndrome. We have a few moments if there are any questions. Breakout group maybe? No. We'll go ahead and take a break then, and we'll come back.